Okay, welcome everybody. I can see a few people still making their way in, but I'm very excited about our meeting we have here today. So I'm keen to get us moving as quickly as we can. I can see there's still one or two people making their way in, but I might kick us along so that we can make the most of the hour we have together here today. Welcome everybody. This is the Human Rights Network meeting. We're going to be discussing the Anti-Discrimination Bill 2024 consultation draft. Very important part of a long-standing process, and so very keen to get through the housekeeping and then introduce you to our wonderful guest presenters today. But firstly, I would like to just take a moment to acknowledge the traditional owners on the lands on which we're meeting here today. So I'm coming to you from Turrbal and Yagara land, and would like to pay my respects to elders past and present and acknowledge the rich culture and wisdom and experience that our First Nations colleagues and friends and family bring to our lives. And I'd like to acknowledge any First Nations people joining us here in the room today. We always extend the invitation if you'd like to acknowledge the traditional owners of the lands that you're coming to us from. We often get great representation across this beautiful state. Feel free to pop in the chat the lands that you're coming from. We can see a bit of a spread of where people are. Okay, folks, so welcome to our Human Rights Network, another extraordinary Human Rights Network here. It's been a busy year for the network, a busy year for government and a busy year for our sector with lots of things happening. I'm going to just run through a bit of context setting and general info, and then get us moving over to our speakers. So welcome to the Human Rights Network. If it is your first time joining us, it's lovely to have you here. We really want this to be as much of a participatory network as possible. We have bi-monthly standing network meetings, our next one coming up on Wednesday that I'll touch on at the end of this meeting. And then we have the wonderful opportunities to host these extraordinary network meetings when certain things arise and certain opportunities come about. The whole purpose of this is to really provide a space for information sharing and practice development around how we can embed the Human Rights Act into practice, policy and advocacy. Very important part of how we work together in the society we live in. And QCOSS is the peak body and strong advocate around this space. It really likes to facilitate an environment where people can share information, resources and understanding. That is where we really hoping that you can bring your expertise and insights today. Again, I've mentioned it's participatory. I'm going to really encourage through the course of our presentations for you to either jot down questions. We'll have about 15 minutes at the end where you can put them forward, or if you're a very keen bean, you can chuck it in the chat and I'll make sure that I put them to the presenters at the end, just to make sure that we've caught as much as we can. So we'll be looking to record this and capture the presentation, and where possible, we'll be looking to share that with our members, and to make sure that we don't miss any of the great content we're talking about here today. Okie dokie. I guess one final thought is we are very keen this whole process, particularly when connected to the opportunity of a submission such as this, where there's two real purposes to what we're trying to do here today. One is that we want to bring our guest presenters so that you can hear from them, have a dialogue with them, and ask lots of meaningful questions, as well as to hear from you, in ways that inform our submissions. So we're trying to promote the opportunity for submissions and really encourage yourselves to engage with the process as much as possible. But then your insights and perspectives are really useful for our own submission as well. So there'll be some polling questions right at the end of the meeting where we'll be checking a few things with you and keen to hear. But that, I think, is enough from me. Any of my team jump in if I've missed any blaring part of the housekeeping. I guess other standard things in terms of keeping your microphones on mute unless you're going to jump in and ask a question. But other than that, I'd really like to take the great privilege of welcoming our guest speakers to present to you today. So we are very lucky to have Scott McDougall, the Queensland Human Rights Commissioner, and Heather Corkle, the Acting Deputy Commissioner, here to discuss consultation draft with us today. So without further ado, Scott and Heather, I'll hand over to you. Thank you kindly.
Thanks very much, Ryan. And can I say a huge thank you to QCOSS for pulling together this event today rather quickly. And I just have to say that the Commission really is grateful for the support that QCOSS provides. And again, can I just thank all of you for participating in the network. I can see there's 66 participants so far. I think 114 or thereabouts were registered. That's great to see that level of interest in this really important piece of our social infrastructure that is our discrimination laws. So thank you, and I hope that today is beneficial for you, but likewise I'm thinking that it's probably going to be beneficial for us because our Acting Deputy Commissioner Heather Corkill has pointed out that she's hoping that we'll hear feedback from you about things that you've picked up in the draft bill that we might not necessarily have picked up. So please, when we get to the end and we're looking at questions, if there are things that you've got concerns about, things that you think you might have picked up, please bring them forward. And there's no such thing as a silly question when you're dealing with a really complex piece of legislation such as anti-discrimination laws. So I might just go to the next slide. Are we able to do that?
Seems to be changing on my end. Might just be a little delay.
Okay. Is everyone seeing a slide with traditional owners? No, I'm
Yes.
not. I'm still on the title slide. Anyway, I might just start by acknowledging and conveying my deep respect to the Turrbal people whose country I'm on at the moment. Pay my respect to traditional owners of all the land on which all of us are meeting today. The next slide after that was just an overview of our presentation today. So today I'm going to be talking about the review of the Anti-Discrimination Act 1991, to more than 30 years old now, the Act. And we'll also be talking about the Building Belonging Report, which was our report into that review. We'll be looking at of course, the Anti-Discrimination Bill 2024. Really exciting to actually be able to read that out and say it, because we've been waiting for so long to actually see this bill. And I'll be talking about what I see as some of the positive changes in the bill. And then after I finish, Heather's going to talk through some of the areas that require clarification. So I'll leave that to Heather to talk about. And then finally, we'll finish up with questions. And as I said, we're both really looking forward to engaging with you about issues that you've identified with the draft bill already. I should point out as well that, like you, we haven't had access to this bill until last Friday. So we've got, and Heather's been coordinating a team of people who are starting to work through the great number of issues that are arising from it. But we are still very much in the early stages of doing that. So we may not have all the answers to your questions, but we'll do our best. And like I said, your questions will help us in preparing our own response to the bill. And I guess I would also just like to encourage all of you to please do make a submission to the Attorney General, even if it's brief. the encouragement and the feedback in support of the bill is important, even at this late stage. So please do take the time to follow through with a submission. Are we getting the slides working at all? I'm still on the title slide.
How
But if
things
you
looking?
see something that says sync to presenter that's in red, just click that and maybe that'll click it back into.
I might just stop sharing and reshare and see if that works.
Sometimes even the computer systems experience Monday mornings. So we'll see if we can get that working a bit better. Okay.
Gives me a chance to see all these wonderful people who have joined us.
How's that working now? I can see the acknowledgement of country slide. Is that what you're seeing, Scott?
Yeah.
Perfect.
Oh,
Thanks.
great. Sorry about that.
So it looks like I'm controlling this. Is that right? We'll see how we go anyway. So just a bit of background to the review. So like I said, Queensland's anti-discrimination laws go back to 1991, and there've been a few amendments along the way, but essentially the architecture of the Act has remained the same for 30 years, so more than 30 years. So it was well and truly due for a review when the Attorney General, then Attorney General Shannon Fentiman, asked the Commission to undertake the review back in May 2021. So many of you would have been involved in making submissions to us about that review, and we had a fantastic response from the community in terms of submissions. We set up a reference group that QCOSS were part of as well, and all that provided a really rich source of information upon which for us to make our recommendations. So in July 2022, we published Building Belonging report, and then the government took some time to consider the report, but in April 23, the Queensland Government accepted in principle all 46 recommendations. There were, in fact, many more recommendations because some of those 46 included multiple recommendations, but the government came on board in principle. And since April 2023, we've been waiting anxiously for this moment that's now arrived, which is to respond to the Anti-Discrimination Bill. So that was given to us, I think last Friday, and we have, like you, until the 22nd of March to make a response to the draft bill. So with the Building Belonging report, we essentially made 5 key suggestions for reform. The first one being that more than just tinkering with the Act, we needed a whole new Act with a very clear purpose to the Act. And it looks like the new bill has delivered on that front. So we do have obviously a complete new Act. And unlike the 1991 Act, there is effectively an objectives clause, which includes eliminating discrimination and achieving substantive equality. So I think that's a really good step forward. We also recommended that the key concepts be refined. So trying to simplify some of the legal tests for discrimination, particularly in direct discrimination, but also in indirect discrimination. And so far, we've seen that seems to have been achieved. One of the real problems under the current Act with direct discrimination has been the court's treatment of the test of less favourable treatment. And many of you who are lawyers would be aware of the problems with the comparator test that we've experienced, particularly the challenge that has posed for people with disability in establishing a comparator from which that will actually work to protect people from discrimination. So that has been addressed by introducing the unfavourable test rather than less favourable treatment. So there's no longer a need for a comparator in order to prove direct discrimination, but you will still be able to use one if it actually is helpful. So that's an important improvement. We recommended that there be a shift in the focus to prevention. So by promoting compliance, by shifting to prevention of discrimination and sexual harassment, and principally that's done through a positive duty, which I'll talk about in a moment. We recommended significant improvements to our complaints system to make it more flexible and efficient and to enhance access to justice. And I'd say to a large extent that seems to have been achieved. And we also recommended increasing protection. So a large part of the report was about reviewing whether the existing protected attributes were adequate, whether there should be new attributes added, whether existing attributes needed to be clarified, but also looking at the extent to which respondents were able to claim exemptions under the Act. And so a lot of the report was around how far those exemptions or exceptions should go. And we're still working our way through those elements of the draft bill. So what is a positive duty? So one of the key recommendations that we made was that there be a broad-based positive duty introduced. The positive duty is a legal obligation to take active steps to protect and promote equality, non-discrimination, and the realisation of human rights. So many of you would be aware under the Commonwealth Sex Discrimination Act, a positive duty was introduced to eliminate sexual harassment in the workplace. Well, this Queensland bill would extend that further to all areas of discrimination and sexual harassment and vilification. The key benefits of a positive duty are obviously that it, as we say, it shifts the focus to prevention, so stopping harm before it happens. But it also shares responsibility. So under our existing Act, the compliance burden really is borne by complainants and victims of discrimination and sexual harassment and vilification. Often those victims are, very poorly placed. I'm sure I don't need to tell this audience about that, and are the least likely to be able to withstand that burden to actually do something about discrimination and to do anything that would have any systemic benefit in terms of litigation is a hugely onerous task to expect complainants to bear. So a major benefit of the positive duty is that it does share that responsibility. It also provides opportunity for education and awareness raising, both generally with the public, but also specifically with stakeholders. So that really does shift the focus and hopefully also the capacity of the Human Rights Commission to take on a much stronger role, proactive role in prevention through education and awareness raising. And then the last benefit is it does enable us to look at systemic issues. So what are the structural barriers that are, or structural issues for that matter, that are contributing to discrimination and sexual harassment occurring in the first place? So we're very pleased to see that positive duty is included. We do have some questions arising as to its how broad the application of it will be, and Heather will talk about those a little bit later on. So if we just look at some of the positive things that we have picked up so far in our review of the bill. And again, I do want to suggest that QCOSS members write in support of the bill, and in particular, you could highlight these positive aspects. The first is, as I mentioned, the shift from reactive to proactive. So rather than relying on the Commission's complaint handling processes to do all the heavy lifting in dealing and responding to discrimination, the introduction of a positive duty really does make that shift from reactive to proactive. The key concept of intersectionality is front and centre in the bill. So I have to say, when we did the Building Belonging report and started engaging with stakeholders, one thing that came through, there were two things that came through really strongly, and the first one goes to the first point I made about the need for the Commission to have a far more proactive role in preventing discrimination and being able to respond to community need without relying on the community to actually bring forward complainants to bear that burden. The other thing that came through really strongly from the consultations was the need for our laws in Queensland to recognise the impact of intersectionality on those people who have more than one protected attribute. So we dealt with that in our report in various ways, and it has been captured in this bill. I really want to spend some more time with the bill to get my head around exactly to the extent that that will be reflected in case law down the track, but at least there is some recognition of the concept of intersectionality in the bill. That's recognised in the preamble, and also in clause 10 in the attribute list, and clause 11 in relation to conduct in relation to attributes as well. So another thing that came through our Building Belonging report and has been picked up in the bill is the central concept of affirmative measures. So these are things such as the equal opportunity measures, welfare measures that you may be familiar with under the existing Act. We recommended that rather than affirmative measures being expressed as exceptions or exemptions to discrimination, that they be seen as positive expressions of equality, and therefore dealt with within the definition effectively of discrimination, so that they can be done without even prompting a complaint that has to be defended by the use and reliance on an exception or an exemption. So that might be seen as a fairly subtle change, but it's a really important change, and reflects that recognition, which I think is recognised in the preamble as well, that sometimes to achieve substantive equality, we do need to take affirmative action. As I mentioned earlier, the other positives are there are clearer tests for direct and indirect discrimination. So a movement away from less favourable treatment and reliance on a comparator test to prove direct discrimination to unfavourable treatment, which is a test that's been used successfully in Victoria for a number of years now. There's also been a simplified test for indirect discrimination, which I think will also be beneficial. The attributes that are protected in the bill have been extended to include homelessness, and I guess in a state which is particularly afflicted by the housing crisis, that it's a national and seems international problem, but Queensland, as I'm sure you're all aware, is acutely affected by this crisis. So I think it is very timely that we would seek to protect homelessness as an attribute upon which discrimination should not be permitted. Similarly, domestic and family violence status will be protected under the Act. Those two things often go hand in hand, of course. Irrelevant criminal record will now be protected, and physical features will be protected. I noticed that physical features is defined in the bill, in the schedule, and excludes things that are effectively within the control of a person, such as haircuts and tattoos. I think we actually recommended that they don't define physical features and allow the common law to evolve in that area, but they've taken the step of defining it. Family, carer and kinship responsibilities will also be protected, and I guess that's a clarification. And immigration and migration status were also clarified and to be protected. So I might hand over now to Heather, who's going to talk about some of the things that are less clear, and then we should have some good time for some questions and a poll.
Thanks very much, Scott. And so just of the, obviously we have a team going through the bill at the moment and still really working our way through, but these are the top 3 concerns that we have come across so far. Some of them are about, I think, clarifications, and others are about, I think, more major changes. So in relation to the positive duty, our recommendation was that a duty should apply to anyone who has a legal obligation under the Act and for all attributes and areas covered by the Act. I don't have the clause on the screen here, but I'm sure others can have a look at it after this. But clause 19 actually has is the duty to eliminate discrimination, sexual harassment, vilification, and victimisation. So while the scope of the contraventions is there, and that's great, our concern is like who it may actually apply to and whether it will in fact apply across all duty holders and across all areas, just because of the framing of it. So those with duties are clearly not a natural person in this clause 19 of the bill. It includes a corporation, partnership, or unincorporated body that carries on a business or operations. Individual people, but only when they're sole traders. So the words business or operations are key there. We have had a look at maybe how this clause has been put together. I think it's actually a mashup of Victorian positive duty clause that's been around for a while, and then also a fairly new one, which is the Commonwealth sex discrimination it's positive duty under the Sex Discrimination Act, but that's only applicable to the area of work. So in taking aspects of both of those, I think it's now become quite unclear as to who's covered. So we are trying to work our way through and try to understand how this has occurred. We are not sure, for example, so in the Victorian clause, it says very clearly that it will include the state, because it also says if you've got a it's notwithstanding the duty that you've got as a public servant, perhaps applying the Human Rights Charter. This version in the Queensland Bill doesn't have an equivalent provision. So in terms of where does the state fit? They're not a corporation, partnership, or unincorporated body, as far as I know, that's carrying on a business or operation. So the first question is, does it apply to the state of Queensland? There is a general clause at the start of the bill that talks about it applying to the state. It's just about whether this particular provision does. And then the other question is like, in the context of a school, is a school carrying on a business or operation? The Commonwealth wording does seem to be partly drawn from the Commonwealth wording, which is business or undertaking. But undertaking, that in that context, it's a lot clearer, because that's only going to be in the area of work under the Commonwealth provision. So whereas it could be anything from a real estate agent in the accommodation space, or it could be a private school potentially that has duties, and so we're just not sure about, with the particular drafting, who's to be covered. There's also some comments that have been made that that have indicated to us that it may not be intended to cover the field, because a media statement made by the government talked about applying to certain duty holders, as well as the consultation guide also referring to that phrasing. So we really need clarity as to who is going to be covered by this. I think any ambiguity could really cause problems for anyone seeking to rely on this positive duty, in terms of, even our ability to then enforce the positive duty. We could be in some serious trouble. So this is why this one's a really important clause. And sorry, this has gotten really quite legalistic quite quickly, so I'm apologising to any non-lawyers here. I hope you could follow that through. But I'm sure that I'm hoping that this might be something that QCOSS can pick up as well. So really, the question is like, from a non-legal point of view, who should have duties who should have a positive obligation to apply the Act? We say that's any duty holders, not select duty holders. So that's what that one's about. Vicarious liability. So when I say vicarious liability, I mean, for example, if an employee has sexually harassed another employee, they may be what we call an individual respondent. Now, almost automatically at this point, their employer, so the person they work for, is going to be jointly and severally liable for that sexual harassment, not just that individual who did the sexual harassment. We have a current provision called vicarious liability, section 133 of the Act, and it just simply says, if any of the persons, workers, or agents contravenes the Act in the course of work or while acting as an agent, both the person and the worker or agent, as the case may be, are jointly and severally liable. But there is a defence to that, where a respondent can show that they've took reasonable steps to prevent that contravention. So reasonable steps has always been the test, not only in Queensland, but I think it's also across all Commonwealth laws as well. So for consistency's sake, it's been pretty straightforward. Have you taken the reasonable steps or not? it's quite a high bar. Currently, we have a lot of case law on this topic as to what it means to prevent a contravention. Though, for example, like if you've told someone through a training program 3 years ago they shouldn't sexually harass anyone and then not done anything else, you probably are going to be liable. So it's very straightforward. And at this point, clear for a complainant, and it is probably on the rare side that an employer can actually show that they aren't vicariously liable. So the difference now is that, and this was not something we made any recommendations on in Building Belonging because we didn't think that there was any need for changes at all. We now have new liability provisions that are incredibly complex. They appear to be drawn from more like the law of tort. And it's actually it introduces a whole lot of new concepts to the Act, which would include looking at a representative, so rather than a worker or agent, so within the scope of the representative's actual or apparent authority. So we're having to look at, rather than just in the course of their work, we have to work out if they had the authority to do something or not. And then rather than reasonable steps, we've got a new test of reasonable diligence. And then there's some other complicated provisions around proving a person's state of mind about a particular act or omission. And those clauses, for anyone wanting to look at this, is clauses 94, 95, 96. We are very concerned about this shift. There's no explanation as to the change. We have really clear jurisprudence in Queensland about the meaning of the course of work. It's construed really broadly, and the interpretation is not confined to the analogies from tort. The expression acting as an agent doesn't require any connection with performance of work, merely the existence of an agency and whether the conduct was within some sort of perceived scope of apparent or ostensible authority is not an element for deciding vicarious liability at the moment. So we consider that these probably could make it much harder for complainants to prove their case against vicariously liable parties. The consequence of that would be potentially that people would have to rely on individual respondents, often who have no financial ability to pay a settlement or compensation or court order if it comes to that, as being solely liable for actions. So we are very concerned about this one and suggest that this is looked at closely. In terms of recommendations, we'd say just return to what we've already got, which is replicating Section 133 of the Act. And really no changes are necessary because it's been well established across Queensland, other state laws and Commonwealth laws what the test should be for vicarious liability in the context of discrimination, sexual harassment, etc. So that's the second of those issues that I've got on the slide there. The third is reasonable accommodations. So reasonable accommodations, the idea for this is that they've always existed. The requirement to make reasonable accommodations or reasonable adjustments for a person with a disability has really always existed in the concept of indirect discrimination, but nowhere in the Anti-Discrimination Act does it talk about that concept, and it's not necessarily very well understood by duty holders. For over a decade, there's been an ability to make a complaint about failure to make a reasonable adjustment in the Victorian jurisdiction, and there was also some changes made to the Disability Discrimination Act as well. And so we were really looking here for an additional provision which allowed a person to say, I haven't been accommodated, I haven't been reasonably accommodated because of my disability, and that should be a standalone provision, which means that a person could both bring a complaint about indirect discrimination and reasonable accommodations. Similarly, how someone could make a complaint about sexual harassment and also sex discrimination based on the same course of conduct. What's actually happened here in the bill is quite different from that. We think it's extremely messy and adds a huge amount of complexity. So what we have in the moment in the bill is that for direct discrimination, it says that if it's a matter of person with a disability, that failure to make a reasonable accommodation is unfavourable treatment for the purpose of direct. It also comes into indirect discrimination again with a different test. And then thirdly, there's another provision which is a positive duty provision, which is not actionable by a complaint. So that's that third positive duty provision. And I should really get some sections and clause numbers for you here, or you'll be a bit lost. That further one we don't think is actually necessary because of that general positive duty provision in 19, we don't think that there's really any need for clause 18, which is an additional duty to make reasonable accommodation for a person with a disability, because that's already applied into that broader positive duty. And what we really need is someone to be able to action that can make a complaint on the basis of that section, and that's not what currently has been drafted here. We have had a look at what it would take for a person to prove that someone's failed to make a reasonable accommodation, and we think it's around an 8-element test right now. Incredibly complicated, considering there's already drafting available under the Equal Opportunity Act, which was very, very simple. One of the things we wanted in terms of creating clearer legal tests was actually reducing complexity for everyone involved, because we know that increases it firstly deters people from making complaints. It also extends the costs of litigation for not only people bringing complaints, but those also duty holders as well. So we really like to strip out the complexity out of reasonable accommodation that we're currently seeing in the draft bill. So those are the top 3 issues. Obviously, there's a lot of other smaller things that we've seen, but those are the major ones. And we'll have some polling in a second where we can have some further discussion about all of that. But just if we go to the next slide, before we move on, just wanted to give you the details of the submission process. We've got the link there on the slide. 5 p.m. 22nd of March is the due date for that, which I know is quite tight. But understand with QCOSS, one way to provide input to QCOSS as well in terms of their drafting of their submission. So we might are we going to polling next though?
I think we might go to questions first. We've probably got about 10 to 15 minutes where we can hear from the group, and then we'll do polling right towards the end. I'll jump in when that's time. So I think first of all, thank you so much, Scott and Heather, for that presentation. Obviously, a lot of content to cover into a relatively small time frame, so that's greatly appreciated. Everyone who's with us here today, I'm sure there's some burning questions that you'd like to put to Heather and Scott. So now is your opportunity either to pop your hand up and then you can ask them directly, or if you're more comfortable using the chat, you're welcome to do that as well. But the time is now if you would like to pose any of those questions to our presenters here today. Okie dokie, bear with me. Sorry, folks. I'll try and get the ordering right. Brendan, I think you were first, cab off the rank. I might throw to you first, and then I'll go to Jenny.
Hello, can you hear me? Hello?
Yep, loud and clear.
Yes, I can hear you.
Good. Hi, excellent presentation. I guess I'm still concerned over the issue around getting legal representation for complainants. Obviously, it's an issue around getting it and actually having it, and it's obviously been an issue that was identified earlier on, and it'd be good to hear whether there's anything in the bill around that. Thanks.
I'm happy to respond to that, Ryan and Heather. So there's the funding of the implementation of the bill is something that the department is obviously in charge of. I think that community legal centres and the legal assistance sector, such as legal aid and ATSILs, I'd like to think that they would be in discussions with the department around the resource needs in terms of implementation of this Act. We do we obviously do want to see less reliance, as I mentioned, on complaints and litigation in order to protect people from discrimination. However, there will always be a need for representation, Brendan, as you've indicated. So it's important that there is adequate funding out there. from my point of view as well, the community legal sector especially plays a really important role in filtering cases that come to the Commission. So there are some cases, test cases, for example, that really do need to be properly filtered and identified as ones that should be backed all the way through to litigation. And I guess on that point, there are some important reforms that hopefully will facilitate some of the test case litigation. So organisations being able to bring complaints where they're representative of the group affected. So I guess the upshot, Brennan, is that those discussions about funding really should be taken up directly by the peak bodies with the department.
And how can they happen before the 22nd of March?
Yeah, I don't know that that would have to happen by then because the funding's separate to the bill.
The bill,
but,
again.
yeah, they should get onto it.
Thanks.
Thank you, Brendan. Thank you, Scott. Before I just throw to you, Jenny, do just want to remind everyone as well if there is anything through the draft bill that you've seen that hasn't been touched on today to jump in as well. Obviously, the 185 pages we've all memorised since it came out, but I'm very keen to just hear your insights as well. Jenny, over to you.
I have so many questions, but I'm going to try and not ask all of them in this forum. The affirmative action aspect, the affirmative measures, does that mean then that organisations and groups that want to be able to employ people with certain attributes such as race, gender, particularly in that queer space, sexuality, that sort of stuff, as an affirmative action measure within their organisation? Does this mean now that they don't need to apply to QCAT for that exemption, that they can just go ahead and put that within the advertisement, or do we still have to do that sort of process through QCAT?
That's a really good question. Thank you. The short answer is yes. You won't need to go to QCAT.
Okay.
I think it's going to be important that organisations that do that are satisfied that what they're doing is affirmative action, and I think the Commission at some point in the future will need to put out some helpful guidance as well. But that is certainly the intent behind the recommendations, and as far as I can tell with the legislation, that's the intent as well. Because what we were finding in many cases under the existing laws is organisations would apply for a formal exemption only to be told that there was already an exception in place under the equal opportunity measures or welfare measures. So we want to make it as easy as possible for organisations to embark on affirmative action campaigns, programs, I should say.
There are a bunch of other questions sitting behind me, or can I ask another one?
I think maybe chuck one more in there and then I'll try and make sure we can touch on the others before we go to the polls.
You touched on housing and homelessness, and I'm very aware that the term homelessness is quite subjective, depending on where you sit. And then in the thing, there's no actual specified definition put forward. That's a really vague definition. Like, you know, so if we start talking about what's appropriate and affordable housing, and if people aren't in appropriate and affordable housing, then they're defined as homeless or at significant risk of it. And then you've got people who are sleeping in their cars that aren't defined as homeless because they've got somewhere they can lock themselves away in other definitions. Is there going to be some guide as to how that's going to be defined in in space? Because I speak to people all the time that are knocked back from employment because they haven't got secure and appropriate accommodation. Does that mean they're going to have that coverage on the homelessness?
There was the intention to actually not define homelessness because it is such a hard concept to define, and therefore the idea in terms of the recommendations and doing so was to have it as broad as possible, so that then there is more flexibility, because we started to think about how we would possibly define homelessness and really found that incredibly difficult. So I guess it would really depend on the first cases that get before the courts and tribunals, which would start to then create maybe some parameters around it. But until that time, you know, it is beneficial. And now that the Act says it's beneficial legislation, it should be construed as broadly as possible and not in a technical way. So that's how we see it. But like, we wouldn't have complete control then over what a court or tribunal thinks is homelessness.
Okay. I'm sorry, Ryan, I'll stop asking.
Look, there's so much to chat here today, and I am mindful of time, so I do appreciate your very insightful questions, Jenny. I will move us along though, and feel free, I think, to contact both QCOSS and the Commission on the email that was up before for any further discussions. I think we could have a session all day and not quite get through everything. I wanted to draw your attention to Jacob's question around changes being implemented, or what, if any, changes are being implemented to the discrimination provisions under the Corrective Services Act. And I guess that there does seem to be some other questions we'd heard in the lead up just around that interface with other acts. Heather, I think you were keen to speak to that. Thank you.
Yep, I've worked my way through this. So unfortunately, only half of what we recommended has been taken up by the bill. That is in terms of making the process simpler for prisoners, because at the moment, well, there was previously a two-stage process before you even saw the inside of a commission that took months. At least this is now actually streamlining it, so you've got consistency with the Human Rights Act internal complaints process. So you do still need to make an internal complaint, but only wait 45 days. And there is the ability for the Commission to waive that wait time if there's any sort of urgency to their matter. So that is definitely a good process improvement for prisoners to cut out some of the internal red tape they had to go through to even reach us. So that's good. Unfortunately, the second part of what we recommended, which is there's different legal tests for direct and indirect discrimination just for prisoners. And also, a prisoner cannot get compensation unless they can show that actions were taken in bad faith. We recommended that all of that should be stripped out as it is inconsistent with human rights. However, that has not been taken up. So unfortunately, the only change is really there's a minor change to sort of the list of factors that need to be taken into account in determining whether it was whether discrimination was reasonable. So something has changed in a minor way, but we wanted those different ways of treating prisoners versus the general population to be scrapped, and that has not occurred. So yeah, that's a quick summary of that one.
Thank you, Heather. Now, folks, I am just mindful of time. There are a couple of questions there from Lisa and Sarah, sorry. I'm going to make sure we can touch on those and put them to both Scott and Heather. I'm quite keen to pop up the polls that we have there for you, just to make sure if anyone has to go right on 11:30 that we don't miss getting those insights from the broader group. So Michael, if you're able to wave your magic wand so the polls can appear for people. These can also, you can be responding to those as the discussion continues as well. So just want to make sure we don't run out of time for these. If you can see them on your screen, it'd be wonderful if you can click through and submit these. And you'll also notice in the chat, you'll be able to see the responses coming through as the questions are up. I can see Heather's responding in the chat as well to Lisa's question. Thank you. Multitasking very effectively. So while the polls are going on there and you're all distracted doing that, Lisa had asked if there are any changes in the bill that will have a positive impact on the education department and the rights for students to have equal access to education with appropriate adjustments rather than just being left at the back of the classroom. And Heather had responded that I think for this to occur in a way that is effective, 2 changes would need to be made, one being to clarify the scope of positive duty to include schools, which she touched on a bit in that slide earlier, and to fix the drafting issues with reasonable accommodation. So, folks, there's more polling questions coming through now. There are 5, I believe, in total, just in terms of managing your expectations. And these are starting to trickle through. Thank you, Michael. And these are really important ways for us to just gauge from our members and your thoughts on your insights into the draft bill. You'll be able to see those. Got a blend of responses there to the third question. Thank you. While those polls are coming through, is there anything, Heather, to add to Sarah's question there? That they've asked from the Queensland Independent Disability Advocacy Network, whether the Human Rights Commission has had the opportunity to consider whether the recommendations made by the Disability Royal Commission report have been embedded in the bill. Heather, did you want to talk to that in any more detail while people are clicking on the polls?
Just to say that it's a great idea that really hadn't even occurred to me. So appreciate it, because we will do that very task. If anyone else has already done that and has that information to share, then please let us know.
Thank you. Sarah, did you want to talk to that in any more detail or mention any opportunities there? Sorry to put you on the spot after using the chat.
That's fine. Thanks, Heather. It's only because, speaking from the Queensland's perspective, is potentially how we are going to look at this and how the bill has potentially. I see that the migration and immigration inclusion might be something to do with that, but in the GRC was more specific to disability. But yeah, I just wanted to make that comment that we'll probably be looking through the GRC lenses when we make our recommendations and submissions.
Wonderful, thank you. Okie dokie. So I believe the polls are going through there. I can see we've got about 2 minutes left. So firstly, I do just want to say that if you haven't had the chance to put a question forward or ask a question here, that you are more than welcome to contact both QCOSS and the Human Rights Commission. Okie dokie. There is one final question that's going to come up in a minute, which is around your experience of the actual meeting. So we're going to do that in 1 second. First, I'll just touch on any questions, comments, feedback that you'd like to send. You're more than welcome to contact the Commission at the AD Act Review at justice.queensland.gov.au, as well as QCOSS at humanrights@qcoss.org.au. The next poll is going to pop up just in a moment. I want to make sure I also reference that we do have the, as mentioned, the submissions will close on the 22nd of March at 5 p.m. That is barreling towards us. Anyone else working in the policy space will know it's been a big year for tight submission windows. So this one almost feels a bit luxurious to have these days, but I'm sure the 22nd will be upon us in no time. And secondly, I just need to also acknowledge and promote that we have our standing human rights network that will be on this Wednesday, so in 2 days' time, which is all around using the Human Rights Act in advocacy. So we've got a Q&A panel with some amazing presenters there to talk through how they're applying the Act in their role in advocacy, which is going to be a fantastic session. I'm always very respectful and mindful of your time here, so please do reach out to us with the emails mentioned if there are any further questions, comments, or pearls of wisdom you'd like to share. Otherwise, I'd really like to ask you to join me in thanking Heather and Scott for their time this morning. It's a great privilege to have them here to speak directly with you, and we really appreciate your time. So final poll coming up. apologies, folks, that the time is always against us in these things, but it's been wonderful to be able to pull this together quite quickly and have such wonderful turnout. So I want to acknowledge your time as well, and thank you for joining us this morning. I'm sure there's lots more you'd like to know and discuss, so please do reach out. Otherwise, I wish you all the best on your Monday morning, and we'll see you at the next Human Rights Network. Thanks again, Scott and Heather.